All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks, it wasn't the proper time to do that. That's now the third interruption. So,
with all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done. I have a number of documents that I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court. I will remind you once again of the Supreme Court rule. It's on a yellow laminated
sir.
Piece of paper that is before you. I checked, I verified, it is.
Accepted in return.
Mr. Brooks, that's yet another interruption. Let me get through this, please.
I just want for the
You will
record,
have an opportunity when I give you an opportunity. No one else is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware that's another interruption. I'm well aware. Stop talking.
Which I have the right to do.
I'm well aware, Mr. Brooks, that you object to the name that has identified on the information and all documents in this case. Your objection is noted. It does not need to be repeated. I will make a record right now. The court notes a continuing objection by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously related to that. Those documents are of record. There's another document that's filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio means to participate.
Removed from the courtroom,
That's another interruption.
And you haven't shown me any lawful case law that I can be removed from the court proceedings in a trial and forced under coercion and duress.
Coercion and duress. Isn't it duress? Yes, I will be mocking him. I gotta double check my words though, but yes. Well, not mocking him, but if he's gonna be a smarty pants, I'm gonna make fun of his words, mispronounces. Because while I say, yes, he's smarter, as I said in prior videos, he's smart in, he's only, well, he does know what he's doing. He's not going to look at any piece of paper they give them. And all he's going to do is stick to his sovereign citizen crap. And that's for lawful law, and I don't go by that name. I wish he'd just have some, inflection. Now I've got to check my own words in his voice instead of I am a third rider, blah, 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 blah. He could at least, make it a little more interesting. That guy there looks like he just wants to bang his head against the wall. But what he isn't smart about is he'll get up there, as you will see, and go on and on and on and say the same things. And some of the things, a few things make sense, but most of it is just a crap load of just him talking and blah, 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 blah. And it still amazes me that it's, as you will see, if you haven't seen already, as the trial proceeds, the horrible things that happen to these people. And again, the people that he calls as his own witnesses that he ran over. Are you kidding me? And again, this is only for entertainment purposes, and I love to research, and I am not a licensed psychologist. I am not a lawyer. But I have done a lot of research in school. I'm an English major, but even then I won't get it right. But I will make fun of some of his words if he says things incorrectly, because I just don't feel that bad for him. I don't feel that bad for him at all, because anyhow, you'll see. All right, so like I said, I'm doing this more for the humor, to make fun of him and his actions, but I will be focusing on the victims, because once we get into that, if you haven't seen it, or if you've only seen a little bit of it, it's just horrific. I think I also identify with it because it's a small town. I grew up in a small town, and while small towns can be a little bit cliquish, I guess you could say, there's also positives. They're a tight community and they back one another. And I actually fell in love with this town and the people there, and what they had to withstand with his ridiculousness and really his evil hatefulness. And look at that man. He's just like, oh my God, I need to change jobs. Okay, let's proceed and see what Mr. Brooks has up his orange sleeve.
To appear in the trial that I am needed,
God.
that I'm trying to express that I have the right
Mr. Brooks, there's a proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility. You interrupt. You don't wait for anyone to finish.
Good Lord. Nobody can talk with him.
It will result with you being removed from the courtroom. So you are once again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple of things, the first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared.
If y'all haven't heard this part, listen to it. It is important because he thinks, oh God, wait till you get to I want to call it a shock collar, but he's shackled to the table, but they'll explain more about that. And a lot of this stuff, he doesn't believe it. I get he could be suspicious or think, oh, they're on him. But they are actually doing it for his benefit, even though he doesn't believe it. Because as I had stated previously, she does not want to have a mistrial. So she has done, and she did very well, everything in her manner not to allow this to happen. But my gosh, What a time.
Previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts around each one of the tables. I'm aware of the feet shackles. That's yet another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly all of the tables, right? So that it appears to be the same for anyone coming in and viewing.
See, she's trying to say to him, but look at him. He's just like, he's so disgusting. I'm sorry. But so, like, his table, the prosecutor's table, everything is uniform with the skirts on the tables. So, but he just, it's all about me.
Again, arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks, I've had many trials with individuals who are in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody.
You know what, though? If you would quit flopping your gums, they probably wouldn't know. But trust me, they're all going to know now. And they do know now.
I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
You're a celebrity now. Wow.
Mr. Brooks, did you hear the question that I asked you?
Yeah, really.
And
Hyundai Alonso.
See, that's the thing. He isn't going to listen. Good gosh, help us all.
You're able to see the screen, is that right? Okay. I'll publish that as well.
Oh,
all right, we are
Lord.
Back on the record. Appearances are...
Okay, so I cut out part of it. I mean, I think his rambling was enough. So, of course, he had to be moved to timeout. And now he's shirtless. I guess he wants to show his sexy self to the world.
As they were before, I need to make a record that at 8:42 a.m., this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system to the other. That is why we're able to see, and when appropriately,
Bust, we see that. Good God.
Hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present. I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these
You think?
last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt. I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself,
Could you please put your
then
shirt
he
on?
may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the preliminary stage prior to the jury being brought in. I would note it's a little after 9:06 a.m. At all times throughout the court's statements thus far, since going back on the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no. At a point in time where it's clear he's disagreeing with something that I've said, I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of his to disrupt, to delay, to create chaos. I will further advise Mr. Brooks that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear if appropriate. All right, I've received a note, we need to reset the Polycom system, so I'm not sure what that means. I'll find out, and if appropriate, make a record as to why and whether that impacted anything that was happening in the other room. But at this point, well, I'm not going to get off the bench. We're going to take a short recess for that resetting to take place.
I would request an opportunity for then, Your Honor, when we go back on the record.
Absolutely. All of them, a simple reboot of the Polycom system over there took care of that, and I have confirmed that it's working properly. Before I turn to you, Attorney Opper, because I'm not sure if Mr. Brooks heard this or not at the very
What is wrong with
end,
his darn pinky
remove
finger?
him, I wanted to make sure that the record is very clear. I will note a continuing
Is it just me, or does he kind of look like a newborn baby from this position? Oh, God help me. Okay, sorry.
objection to the issues he raises regarding his name and other things. There are filings that substantiate that. It will be my position it's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially, he appeared before two court commissioners. He's had counsel representing him up until last week on this case, and you made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I would also add to
buffering. Come on. Oops. Okay, hang on, guys. Let me fix
he is
this.
coherent, he is intelligent, he knows the issues in the courtroom, he discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written. His handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated, and the court has seen this since August 25th or so, as the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. And I want to make that record. I tell this court as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record, as to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get justice for the crime victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty, that doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opper, and I do appreciate you raising that with the court because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit so that that can be part of the record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done, as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding. We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things. Frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction, as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence. And so I wanted to make that record. I don't have anything from him this morning regarding any additional jury instructions. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have,
Any objection to those?
no.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection
Should be
to
good.
the jury instructions that were provided to you yesterday.
I don't know.
I'm specifically
I don't
looking
understand.
for a yes or no answer, and I'll address further if need be based upon that yes or no.
I don't go by that name.
The microphone is unmuted.
He's going to pretend he can't hear. They're going to tell him, oh, they're going to, am I muted?
Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second. Where is the microphone? It looks like it's in front of the monitor. Mr. Brooks? Try again.
Am I on the record?
You are on the record. Ooh, that's loud.
On
now.
the
Turn
record.
that down.
Oh, God.
Mr. Brooks, do you, yes or no question, do you have any objection to the preliminary jury instructions
Yes, I
that were
do.
provided to you yesterday?
Oh, it's good.
Go ahead.
Take him
answer,
off
please.
now.
All right, your objection is noted for the
I
record.
object. Oh,
And
God.
I'm just putting the mute back on. He provided that objection without any legal basis. I muted him just so I could ask this question.
He can
I'll
hear.
be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, it's the volume is not being appropriate at the moment.
Oh, get over yourself.
There needs. Try it again, sir. I apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately
Oh, my gosh.
working.
You have
I do
time.
appreciate that he was able to
Oh.
hear me because he leaned in to answer.
Oh, he
So I
can
just wanna
hear.
make that record. I'll take, I'm gonna go take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there.
Okay. So, if I'm not mistaken, this is the next day, the day after DB made his shirtless debut. DB made his shirtless debut and also was a whiny baby about some sort of little cut he sustained and a bruise on his arm. And from my understanding, and I think we all heard this, is that it had something to do with when he was escorted out of the courtroom to go to the timeout room. Somewhere during that, there was some sort of altercation. Sounds like to me he was resisting the officers and got injured. But the injuries do not appear to be that bad. But let's see what he has to say.
Just like the record to indicate that I understand we did not follow up with this after the lunch break on the record, but it was my understanding that Mr. Brooks did receive the medical attention that he was seeking over the lunch hour. So I just
Very
wanted
good.
that on the record. And then finally, Your Honor, just a reminder to Mr. Brooks as to the other acts evidence. In line with his questioning of Corey Runkle yesterday, Erica Patterson will be testifying here this morning. The court issued a ruling as to the other acts evidence. The state strictly abided by that. Mr. Brooks came very close several times to opening the door to that testimony. We treaded very lightly on purpose to be respectful of the court's ruling, but the court warned him twice. Mr. Witchow even personally went over and warned Mr. Brooks during Ms. Runkle's testimony. And before we start another round of challenges, potentially during Ms. Patterson's testimony, we just wanted to make a record of that so that Mr. Brooks knows if he opens the door to that other act's testimony, it will come in.
I appreciate you raising that as well. Mr. Brooks, on the issue of medical attention, did you see the jail nurse or other medical personnel during the lunch hour yesterday?
Yes, I did. I received a cleaning of my cut and a bandage.
I'm sorry, a cleaning of his cut and his bandage. Well, the reason why I sound so disgusted is because later on you're going to see him cross-examine and under direct examination, question people that he subpoenaed, people that he ran over, and make light of their injuries. That's what makes him so disgusting. Anyhow, I shall proceed.
All right, thank you.
Oh, I'm sorry. I was getting to the other parts of the injuries there.
Oh my God, the other parts of the injuries. He's worse than a school child. Oh, let me show you my boo-boo. I got a bandage. Oh, wait a minute. I got to finish up the rest of my injuries. Ugh. Okay, sorry.
Hey,
Go ahead.
viewed the bruises that I have on my arm and legs as well.
Oh my gosh.
I don't know what's gonna happen behind that, but I was looked at.
I think you'll
All right,
survive.
thank you.
Didn't have tire
It does not
marks on
appear
you.
to me that any of these injuries are interfering in any way with your ability to be here today and assist in your own defense. So that's good.
Yeah, I'm just a little tender, just a little sore.
Oh, he's just a little bit tender.
All right.
Oh, bless your
Mr.
heart.
Brooks, do you understand what the state is?
What an idiot you are. No, I'm sorry. I thought she was going to say, do you understand what an utter idiot you are? Okay, sorry. Here we go.
Referencing as it relates to the other act's evidence?
I do not understand.
Do
course you
recall
don't.
being in court at the end of August when the court addressed a number of motions, including a motion brought by the state to admit other acts?
And with all respect, Your Honor, this whole.
Why can't he say yes or no instead of going on and on and on?
Process is very, very new to me. So
And it's new to you, but none of us really care because you chose to represent yourself. You ditched your two public defenders. Remember, you said it didn't make you flinch one bit. So now's not the time to pull the pity card out for yourself.
I'm trying to
Wrap your head around it.
I guess stay within bounds of the questions that I'm allowed to ask. If
Please. You don't
I color
try to
outside
do
the
that.
line, so to speak, it is
Color
not
outside the
intentional,
lines. You don't even color in
because
them.
I'm basically learning as I go.
Oh,
So I'm
yeah.
going to have my clerk print out the motion for other acts that was filed by the state, along with the response that was filed by your attorneys at that time, and further advise you the court did not grant the state's request to admit other acts as it relates to your conduct with Erica Patterson prior to November 21 of 2021. And your questions yesterday of Ms. Runkle could have opened the door to the court revisiting that issue. That's why the court stopped. It was interesting. Ms. Runkle clearly was advised not to talk about other acts. The state followed the requirement that they advise their witnesses about the court's order as it relates to other acts. And I believe I kind of paused twice and said, are you sure you want to answer that? I referenced generally some prior rulings so as not to alert the jury to anything more than that. And then at one point, Attorney Wichow also came over, muted your microphone. I don't know what was said, but my understanding is he basically kind of gave you the same caution. There's a ruling, something to that effect. And I know you didn't proceed with the questions that you had originally attempted to ask this witness. So it's very clear what we're talking about. Again, I'm going to give you these filings so that you understand what I prohibited in this trial. And the record should reflect those filings are being provided. Madam Clerk, do you happen to have the document numbers for those? Sorry, I should. 170. Document 170.
And just for 1 second, you know what's so interesting, and I know I keep going on about it, but you understand why I think at this point, even if you're new to this. The court really does bend over backwards to make this a fair trial, which means seemingly licking DB's boots at times, but not really. There's a purpose for everything. I think many times throughout this, the judge just lets him go on his tangent because it just makes him look worse. But she gives him all these, again, documents and papers and things in order to help him. Now, he may read some of them and then just say he doesn't, but he'll usually toss them, rip them, throw them in the garbage, or he'll almost always say he did not receive them. He doesn't understand. He doesn't understand. He doesn't understand. And it is so aggravating. But I just had to pause to say that to you.
And 161. So documents 170 and 161 were provided to Mr. Brooks. So the only other thing I'll say on that, sir, is if you ask questions, I'm not going, that would open up the door potentially, or at least ask questions that call for answers that might fall within that order that I issued. You do that at your own peril, and you may open the door to the state bringing in other witnesses and other testimony about those issues. So I want you to be advised of that. You are correct that when the state
Oh God, he's getting ready to talk again.
made the request,
Jeez,
I prohibited the state from introducing that evidence.
Look at this
so you're
guy
not
over here
incorrect when you
too.
say
He's
I
like
didn't.
going,
If you
please.
when you kind of referenced about that was there's a difference between me prohibiting you and prohibiting the state. But from my perspective, the order that I issued was to your benefit. And so you can ask those questions. You're not prohibited, but then you potentially open the door to that information becoming admissible in this case. So I want you to be advised of that.
May I quick, Your Honor?
Go ahead.
I would just like to say that I accept for value in return for value these filings. I do believe that I have a little bit more clarity. If that helps.
Thank you for putting that on the record.
Yeah.
Do you have any other issues you want me to address?
Just very, very quick.
Very, very quick. Please, God, please.
I still don't understand the nature and cause of the charges against me, Your Honor. And
he doesn't understand the cause or the nature or the cause of the charges, or of the things charged against him. Sorry. He does understand. He ran over people. They have photos of them. I don't want to jump the gun, though, because you'll see them if you haven't seen it yet. And also, again, he already has been charged, convicted, sentenced, all that. Of course, he is appealing all of this, but yes, he was charged guilty on all accounts. Just to make that clear, I'm not rushing to judgment.
I still would motion for, or tennis motion for the jurisdiction to be proven. Subject matter jurisdiction.
This is the same stupid stuff he brings up over and over again.
And also a motion for finding a fact.
This has nothing to do with anything.
Your requests are all noted for the record, and for the reasons previously stated on this record, I'm not going to answer those requests any further. They've already been denied by the court. I'd point you to the case of, can I have my post-it note back? The Beneby decision at 654 F 3rd 753. All right, anything else, sir?
I'm not interrupting him.
Please don't act all polite. Oh, I'm not interrupting. I think he's going to be a total ass.
Just for the record, Your Honor.
For the record.
The record to reflect.
Okay, here's another thing. I'm sorry. He'll say, for the record, I want the record to reflect. The record is reflecting. Anytime anybody speaks, the record is reflecting. For the record, I want the record to reflect. Just spit it out, dude.
Is that a judicial determination that you are making?
Oh, God. There you go. Is that a judicial determination you're making? Oh, give us a break. That guy's going, you got to be kidding me. Officer behind him.
Your Honor, Mr. Brooks, the record speaks for itself. I've made my decision. We're moving on. All right. With that, then, State have a witness available to be called.
We do. Would you also just make a record, Your Honor, this morning that Mr. Brooks does appear again in his orange jail uniform, and that he was offered the ability to wear street clothes and declined that offer? Also, he does have appears to have all of his discovery materials at the table with him.
Yes, thank you. I should make a record of that as well. I didn't state at the outset Mr. Brooks is here in person and in custody. He once again has come to the courtroom in jail attire. I presume, Mr. Brooks, but please confirm for me, you were offered the opportunity to change into street clothes?
As I stated on the record yesterday, I'm waiting for the results of the COVID test that I took. So until I get those results back, I would prefer to not wear street clothes at this time.
All right.
And yeah, I kind of flip-flop these, but they're just within a day or something apart. It's still, what does having, why would he wait to get his test results to not put on a suit? That's just another ridiculous. He just loves to be obstinate.
Can you confirm for me, though, that you were provided an opportunity to change into them if you so chose?
And not to my knowledge.
Sir, I'm providing you with that opportunity right.
Okay, see, he's saying not to my knowledge. But that means, again, he was offered. He says this all the time.
Now, if you would like to change into your street clothes, into the suit and tie that you had previously, or any other street clothes, I would give you that opportunity. Did you hear me advise you of that just now?
I might consider it. Maybe I may have more information from the medical staff once we take a break, or maybe anticipating.
We all know.
Actually, I anticipated that I would know before we even
The guy behind
court.
them, the officer, looks like he wants to laugh.
Do you want me to have the bailiffs ask the CO if there's any new information that can be relayed to you before we bring the jury out?
That would be helpful, Your Honor.
Do you have any objection? I could email the jail administrator if you want, or I can just simply have the bailiffs do that.
Whichever works best for Your Honor.
Look at him. He's trying
She's
to
not going
be
to give me information in an email, that much I know, but I could at least
so
find out if there's new
accommodating right
information.
now. But
If there's new information, then it's going to have to be given to you.
It's brief-lived, folks. Let me just tell you. I'm being, whichever would be best for the your honor. Blah, blah, blah. Nah, very short-lived.
That may require you to be taken into the holding cell to be given that information, okay?
I'm okay with that.
Okay. Let me just continue that. Again, right now he's in the jail attire. We're going to give him an opportunity to see if there's any update regarding the testing that was done earlier this week. And until we at least get word whether there is new information or not, we'll not bring the jury out. I will make a record that Mr. Brooks does have the 3 boxes that have been referenced previously. I see the objection sign. I see the selected statutes that the court provided to him previously, and I see he has a number of papers in front of him. So he looks as if he's prepared to participate meaningfully today.
Please don't talk. Oh, God.
I did bring these boxes up. I have not had the time to go through everything in there. As you can see, it's a lot.
We're supposed to feel sorry for you about that?
A lot. So I have not had the time to go through everything.
How many papers are in there?
We
don't care. No sympathy here.
Deputy Wittig, any new information? All right. Well, can you provide that? Well, we'll just do it. All right. All right. The information that I have on whether there's new information is they don't have the results, but medical will be called again to check on that to see if anything.
However, if you'd taken the rapid test, you would have already had your results.
Available, but as of right now, there's not. I also was advised that you were offered 3 times to have street clothes by Officer Gabor. Just want to make a record.
Hear that? He was offered 3 times to change into street clothes. He thinks he's so slick. But in many things, he is not.
Of that. All right, then, Mr. Brooks, we don't
say another word. Shut up.
I intend to
say
just
another
continue then, okay?
Really quick.
Really quick, really? Oh, gosh.
To the decision of Your Honor for me to be removed from the proceedings over the last few days.
You mean removed because you were a raving idiot? A disrespectful ass? Is that what you were referring to?
That was used from the Illinois versus Allen, right?
Correct. I also had cited to a case that I believe is on point, although not binding on this court. I am persuaded by the reasoning in United States versus Jennings, found at 855 F Sup 1427, which is from 1994. From Pennsylvania, and as well as, just that one. That was affirmed by the Third Circuit in United States v. Jennings, 61 F. 3rd, 867. Third Circuit, 1995. So the first decision I referenced was a federal district court decision, and then the Third Circuit decision. Let me know if you need those citations again.
Does any one of those mention the being present through audio and visual
Yes, audio. In other words, the
Would that be
defendant in that case, who also was a pro se defendant, was removed from the courtroom after
Was also a pro se defendant and a jerk.
he said he would continue disruptive conduct in the presence of prospective jurors, but he was able to continue to listen to proceedings through loudspeakers and transmit messages to the court, was barred, and what the court held is he was barred from the proceedings by his own conduct, not by the court, and the conviction in that case was affirmed. Do you want that citation again?
No, I'm not interrupting, am I?
No, go ahead.
Don't ask that, because you know you're going to do it later.
I do represent myself pro per. I would like that stated for the record.
Please,
like
we
the record
know.
to reflect that. Not pro se.
We know. We know.
The
We
record
know.
will so reflect your choice of term to describe your appearance today.
I've briefly
term.
read Illinois versus Allen. It didn't say it didn't give any reference at all to him being present by audio or visual in that case whatsoever. It just strictly talks about the reasons that he was removed and the options that the judge had in that. One of them being that he could be bound and gagged. One of them being that he can be held in contempt and removed from the courtroom while the trial would continue, but it did not say anything about being present visually or audio or by audio.
Well, I appreciate you reading the case, sir, and providing that information. I'm well aware of what the case says, and as that case says, the Supreme Court talked about there would be no one formula for maintaining the appropriate courtroom atmosphere, and no one formula will be best in all situations. But the Supreme Court said this: we think there are at least 3 constitutionally permissible ways for a trial judge to handle an obstreperous defendant like Allen, going through the 3 things that you identify. And my findings here are that there's a 4th way, and that's through the wonders of technology that weren't available in 1970 when that decision was authored. So I appreciate the notation on the record. You are here today, and I hope you stay here today. That's certainly my preference. You've demonstrated you're able to prepare, you're able to ask questions, you're able to articulate in a clear, coherent, cogent, and responsive way. And I'd like to bring the jury out. That's what we're going to do next.
I'm not interrupting real quick. I just want to...
Hell yeah, you're interrupting. He's trying to act. This is, see, some days it's very rare, but he has suck-up days to the judge. But you know, we all know, if you've seen enough of him, that within a few days he's going to be an ass. An ass again. But let's just watch.
Say something very quick to that.
Very quick, sir.
Oh my God.
I don't see that 4th way, Your Honor. Also, when he
Mr.
talked...
Brooks, my decision stands from previous. If you believe there's any error that I made, that is for you to address if there is a conviction and on appeal. But my decision stands. And the record speaks for itself.
It's all on the record.
Put it on record.
Yes, please put it on the record. But it's
I
only
intend
on.
to appeal that.
Yes, please, for the love of God, appeal it.
Understood. You may appeal as you deem appropriate.
Thank you.
All right, thank you. Let's bring the jury out. I will ask everyone stand for the jury out of respect for them.
Do you see that? How he's starting to stand up? This is the Brooks maneuver. So he thinks he's being real slick. Now we know that his behavior is about like that of a toddler or perhaps a middle schooler at times. So she asks everybody to stand up out of respect for the jury. So he looks like, I'm like, okay, cool, he's going to stand up. But then he does what I shall now call the Brooks maneuver. He stands up, he stretches a little bit. Then he eases back in his seat And he looks around just like a child to see. Like, oh, look, I got away with something. Is she going to say something? Is anyone going to say anything? Just watch him. Yeah, shake it out. Yeah, looks like he's going to stand. But then watch how he slips in there. Then he's going to peek around. Is everybody looking? Ooh, anyone looking? You are so slick. Oh my God. Yeah, let's rearrange our orange shirt. Yep, everyone's standing but him. Look, because yep, nobody's gonna say anything. Ugh. And that's where we will leave this one for today. And trust me, this is just getting warmed up. Until next time, friends. Love you all. Be kind to one another. Be kind to you. Love you. Bye.